Hello and welcome to this edition of Dr. Clark Reports. I'm your host, Dr. Gary Clark, and my guest is my friend, Judge Harry Cantrell, who is the magistrate judge in Orleans Parish. And Judge Cantrell, greetings and welcome.
Oh, thank you very much.
Yes, sir. And you are now you've been on the bench now for 11 months or so, but then you have been reelected without opposition.
That is correct.
And that is truly outstanding.
Well, thank you.
And but would you please tell my viewing audience the nature of the magistrate judge office and what your duties and responsibilities are?
Okay.
Yes, sir.
Be glad to do. First of all, I'd like to take a point of personal privilege and thank the voters for electing me last November, and also thank them again for giving me the opportunity to run unopposed and be re-elected to serve for another 6 years. So I just wanted to thank the voters of New Orleans. And
That's wonderful.
Thank you. Now, Magistrate Court is a section of criminal district court for the parish of Orleans, and we have the primary purpose of setting bonds for those individuals that get arrested for a state misdemeanor or a state felony. And we also have the responsibility of signing search warrants and arrest warrants. And there's some other preliminary matters that we address in magistrate court, but those are our two primary functions. Now, let me expand on setting of bonds. After a person is arrested for a state misdemeanor or a state felony, the United States Supreme Court has interpreted the Sixth Amendment to the Fourth Amendment to the United States Constitution to say that a person that's arrested has to be brought before a judicial officer within 72 hours, meaning a judge within 72 hours. And in, of course, our system of government, which you're very familiar with as a professor of politics, you know that there are checks and balances. And a person, certainly because they are arrested, they still have certain constitutional rights. It doesn't mean that when they get arrested, doesn't mean that they are convicted or that they are convicted of that crime. So once they're arrested, according to the United States Supreme Court, they have to be brought before a judge within 72 hours. And we have one of the best systems in the United States. They come from all over the United States to look at our system because we bring those individuals before a judge, and that is in magistrate court, within 24 hours. Now, we were able to do that because I'm the magistrate judge, but I have 4 commissioners that work with me. Okay? So we sit 24 hours a day, 7 days a week, 365 days a year. As a magistrate judge, I am on duty from 8 o'clock Monday through Friday until 4 o'clock. My commissioners come on at 3 o'clock, and they handle the magistrate duties from 3 o'clock Monday through Friday until 8 o'clock that next morning, Monday through Friday. Now, on the weekends, they come in, commissioners come in twice, 10 o'clock and 5 o'clock to hear to determine bond on those individuals that have been arrested in certain hours, and I'll talk about those in a minute. And then on holidays, we rotate holidays, so magistrate court is always open. There always has to be a judge or a commissioner on duty to hear the arrest, to determine, to set the bonds, and also to sign and be available to sign search and arrest warrants. Now, what we do, as I said before, is we rotate those, but they come in and we have 3 hearings in magistrate court. We have a 10 o'clock a.m., which I'm responsible for Monday through Friday, and then we have a 3 o'clock bond setting and an 8 o'clock bond setting. And that's determined at the time of arrest. Once a person is booked, if they're booked at 8 o'clock, before 8 o'clock in the morning, then they'll come to my 10 o'clock, they'll come to the 10 o'clock session for me to set bond on them. If they're booked before 1 o'clock, but after 6 o'clock in the morning, they'll go to the 1 o'clock session, 3 o'clock session to have the bond set. And if they are booked after 1 o'clock, but before 6 o'clock, then they'll come before a commissioner at 8 o'clock. So it's a round-the-clock operation, and that is to guarantee certainly their constitutional rights.
It guaranteed the speed part and parcel to the speedy trial process.
Yes, you're right. To make sure that they're brought before a judicial officer because they're only arrested. They're only
Right.
accused at that time. They're not convicted.
Yes.
Okay, so they have certain constitutional rights, as you're well aware of, and certainly have rights after they're convicted. But we try to make sure that the criminal justice system and the Supreme Court has made sure that those rights are being protected.
Well, one actually has to really, they don't understand about the nature of the magistrate until they get into the system.
Correct.
Once they get into the system, then they learn very quickly, do they not?
They do. They do.
Yes, sir.
Unless and I compliment you on having me here, because we like to go out and try to explain to the community, because they don't know unless they get into the system, and the citizens don't understand always what happens in magistrate court. And unfortunately, things happen to people. They get arrested, okay, and their family, they may not know what to do or where to go and those type of things. So compliment you on.
Thank you. They have no idea. It's almost when your car breaks down. You have something happens to your vehicle. If you're not a mechanic, that's when you begin to learn real quickly about how your engine operates.
Exactly.
Yes.
And in fact, what I do in magistrate court and my commissioners is, once they are brought in, because it can be very complexing at that point, I actually explain in my opening address to those that are brought before me. I try to explain what is going to happen to them and how the system is working from this point in magistrate court and what it's about, and also advise them of their constitutional rights.
That's highly important. Now, the one area that I know that all of us tend to question is the nature of the bond.
Mm-hmm.
What are the parameters that go into the setting of a bond, and why is that so important?
There are 14 factors that are outlined in the Code of Criminal Procedure, okay, that we use to set bond. And in my address to the arrestees, when they first come in, and I explain to them the process, I tell them that there are 3 primary factors that I look at as setting a bond. I'm going to look at their prior criminal history. I'm going to look at the seriousness of the charges, okay, and the seriousness of the charges and the extent to which they've perpetrated those charges, okay. So those are the 3 primary factors that I look at, okay, in setting the bond. Prior criminal history is very important, okay. The seriousness of the charges that are before me, okay, are important, okay, and the extent to which they've committed those
right, those priors, as if they have a long history, then it raises an eyebrow, a red flag.
That is absolutely right, and especially if they've had prior conduct that's similar to what they're being arrested for. And I said before that second factor is the seriousness of those charges. I mean, like if you got, you have a second-degree murder or a manslaughter, you have a dead body, or a person, okay, then that's serious, okay. Armed robbery is another serious offense, okay, because the public is being put in, of course, in danger, but they could be put in danger of losing their lives, and lives are of most importance.
What about the individual's capacity to meet the bond?
That is one of the factors that's taken into consideration also, okay? And what we have tried to do is we have a vehicle called release on their own recognizance, or surety bonds, okay, personal surety bonds, okay? If a person is a low-level, first-time offender, okay, has never been in trouble, then we have an opportunity to release that person on their own recognizance, okay? So we try to minimize and look at their ability to pay, all right? And we take that into consideration. We can release them on their own recognizance, so all they have to do is sign, okay? Sign themselves out. There's no cost to them, okay, for them to do that. Now, we do take in for the more serious offenses, we always take into consideration, okay, their ability to pay, but we have to balance that, okay, with the seriousness of the offense.
Right, because the ability to pay is as opposed to, well, I would imagine as well that you see a number of repeat individuals come before you, and you know and recognize them.
Right. Yeah. Unfortunately, they're recidivists. Yeah. There's some that come before us, come on a repetitive basis, and those individuals, if they get convicted, again, if I don't determine innocence or guilt, okay, at a at the initial bond setting, okay? But certainly I'll take that into consideration, their prior history when they come before me and I'm setting their bonds, okay? If they're repeat offenders, then we've got to look at, okay, them being in the community and the danger that they may cause to the community.
Now, and I know that you have certain initiatives that's important to you, such as not only the bond activities, but preventive measures. And if you can tell our viewers about the nature of the preventive measures that you want to have in place in terms of keeping our community safe.
Okay. One is we have a domestic violence court, okay, and domestic violence court is a very important component in our court intervention services, and we intervene once a person is arrested for domestic violence. We intervene, the court, and I say we, the court intervenes immediately. And what we do is, of course, we set a bond based upon that, but we also issue a stay-away order, which means that that person can no longer have any contact with the victim. Okay, there's a stay-away order. And of course, if he violates that stay-away order, if he contacts that victim in any manner, then that person that person can get charged with another crime, which is a violation of a protective order. And I take it very serious, along with my commissioners, when a person violates a protection order, because that's supposed to be a protection for the victim. Okay. Now, there's also been a new law that's just gone into effect on August the 1st, 330.5 of the Code of Criminal Procedure, which says that now, okay, if a person is charged with a felony domestic violence crime, that we don't set a bond for 48. Well, the law says within 5 days, but we determined it 48 hours. Okay, so that person has to really sit in jail, okay, for 48 hours before a bond is even set on him. And this was passed in the last legislative session. As a result, they called it Gwynn's Law. A lady in one of the other parishes was killed because the abuser had been released. Okay, within 24 hours he went back and he killed her. So the interest groups lobbied and they had that law passed. So now they have to sit in jail at least 48 hours before we can set a bond. And
a lot of individuals who may be first-time offenders will not even know that. No. And that provides, I would imagine, a cooling off period, and also a period for everyone to separate for a while.
That is the purpose. You're exactly right. It's called a cooling off period. Let them sit there and just, because at that point, when it happens and everybody's emotions are high, okay, not only the victim but also, okay, the alleged perpetrator. So that 48 hours or with the 48 hours gives them opportunity to sit there and try to cool off, and for everybody to just think about what has happened.
And I can imagine what it's like to cool off in Parish Prison.
I don't know if it's cooling off or it's getting hot back there.
To say the least.
Right.
Now, I like the fact that you mentioned what you take seriously. If you will please tell us the nature of your temperament that you bring to the bench.
Okay.
Because I think a judge's temperament is so important. Yes, sir.
Yeah. Well, it's interesting because although I'm bound, of course, I take an oath to support the United States Constitution, the United States laws, and the state laws. But I've also found in my last 14 years that I think that a judge can have heart. Okay, and I say that because a lot of the, especially the first-time offenders, okay, I think would deserve an opportunity if it's not a serious offense. And we see a lot of substance abuse cases.
Yes.
Possession of cocaine, PWIT, distribution. The substance abuse cases, I feel that those individuals, if we could get them some help, okay, that we may not see them back in the system again. They too are victims to the extent that it's an illness, okay, and just like other illnesses, we can try to treat those illnesses. And what is interesting, Dr. Clark, is that of course, I started the criminal justice program at Southern University, and I was assistant professor for 31 years. Okay, I'm on leave now, but I'm still assistant professor. And I've seen through those 31 years in my contact and as a commissioner for 14 years and now as a judge, that a lot of individuals that come before my court, okay, first time for the low-level offenders, okay, if we get them some help, they don't return.
Exactly.
They don't return.
Yes, and
So
that's your experience kicking in.
that's my experience and my educational background. Okay, as being a professor, and I'm working with the universities now, where I'm going to conduct some formal research. And at Southern, we had a criminal justice research course. Well, I've talked to Dr. Penny, and this semester we're going to have some students come down. We're going to start doing some formal research so I can go back to the community and say, okay, based upon empirical research, that this is in fact what happens, and this is why we need the need to have programs to try to assist people.
Yes, that's it. Because that data, once you have the data, that is so important, because that provides the support that you need. And again, I would like to remind my viewing audience that I'm Gary Clark, and I'm speaking with my friend Judge Harry Cantrell, who's the Magistrate Court Judge here in the Orleans Parish. And Judge Cantrell, I've known you for so many years, some 30-some odd years or so, and I know that you're a native actually of Detroit, but would you please tell our viewing audience the Harry Cantrell Jr. story?
Okay.
Yes, sir.
All right. Well, I came here after I graduated from undergraduate school. I came here and the law school in 1978.
And where did you go to undergraduate?
I went to undergraduate school at Wayne State University.
Wayne State, oh yes.
Yeah, Wayne State, and then I did a year at University of Detroit working on my master's in business administration, because at that time, I upon graduation, I was recruited by Detroit Bank and Trust, and I went into the management training program. And after 8 months in that program, they selected me to become a trust aide, and I worked myself all the way up to a trust officer. But most of those individuals in there were in fact lawyers. Okay, and I decided that if I wanted to advance, then I would go ahead and needed to get a law degree. So I decided I wanted to get my law degree, and Southern University was recommended. I had several friends that had gone to Southern and graduated, and they recommended Southern University Law School. And I applied, and I was accepted on the last day before registration.
Oh, wow.
They called me and told me about 4:30 that I had been accepted and that I needed to be down there on Monday to register for classes. So that was the beginning. I came down to register for classes, and I went back and I informed my instructor that I was going to be leaving to go to law school, and that was in 1978. In 1978, I came down, went to law school, and after my first year, I was recruited by the city of New Orleans, okay, in particular Dutch Moriel, to serve as a law clerk in the city administration in Baton Rouge, and it was interesting. That was the first time that the city attorney had reached out to Southern University Law School to seek, okay, a minority student to work in the city's delegation.
And you were a pioneer during that period.
That is correct, and Dutch was the one that was responsible for that. And what I did as a legislative aide, of course, would be we had 3 lawyers in there, Mr. Anselmo, Mr. Neely, and Gary Foster. And they would handle all of the registry.
Gary Foster,
right.
Yes.
and in fact,
we don't become state rep.
Right. In fact, Gary was the one that Dutch Mayor Moriel had told to go over to Southern to recruit someone. So Gary's the one that recruited me, interviewed me, and took it back to the mayor, and the mayor approved it, and I was hired. But what my function then was to assist that delegation if they needed to get something to one of the legislators on the floor. It was my responsibility to go down, because I had credentials, to go down to that legislator and hand them whatever information they wanted to get to them about a certain bill and that type of thing. Then after the session was over, okay, I was fortunate enough that that they brought me back, and I worked as a clerk in the city attorney's office. And that was my first year. And then my third year, I was fortunate enough to work as a law clerk in the Attorney General's office, okay, for the state of Louisiana. And that was in the criminal division. And I was recruited and hired by he's now a deceased criminal court judge, Pat Quinlan.
Oh, yes.
Okay, and little did I know that at some point in time I would be practicing law under him, but he was an assistant attorney general and recruited. And then I went on and I graduated in 1981 in May, took the bar, and I was successful, and I passed it. And I was sworn in October of 1981, and during that period, let me back, I worked for Charlie Elwha as a law clerk, okay?
Good experience.
Real good experience. I learned a lot about the practice of law from Charlie, and after I graduated, I passed the bar, I decided I was going to go on my own, okay? And in the meantime, I had joined New Zion Baptist Church. And of course, New Zion Baptist Church was very, very active. And I'll never forget, Jackson Acox came up to me after I had joined. He was a member of New Zion, and said, "We're glad to have you, and understand that you're a new lawyer, and I'd like to talk to you about some of the things that we do here." And he approached me about joining OPPVL, Orleans Parish Progressive Voters League.
2020 okay. Jackson Avenue.
That's right, exactly. In fact, that's where I met you here.
Exactly.
and I joined, okay, and of course, you know what we did at OPPVL, interviewed candidates and supported candidates, okay, for office. And I joined, and that was, I think, the beginning of me getting involved politically in the city of New Orleans, and it was very rewarding process.
Yes, and that church produced, if I recall, the first black city council member.
A.L. Davis.
A.L. Davis.
That is exactly right, exactly right. So it had a rich heritage. That's also the church where SCLC was founded.
Amazing.
Okay,
it's a big historical background.
Exactly.
Now, through your experience in the city, and what I think that the perspective that you bring to the city and to the judgeship is that you understand the community, and you operate on all levels and all layers. How have you seen the community evolve, not just after the Katrina period, but period since your tenure here in the city?
Well, the thing is, I think that during those early years,
yes,
especially with OPPVL, how important and how we attempted to, and I think we were successful in stressing to the community how important it was to vote. Okay, because that's what we were about, getting the vote out.
Civic engagement, political participation, yes.
Exactly. And I think during those years it was pretty heightened, you know, because we had an interest in getting those people elected that would represent us and represent our interests, okay? But I think in the recent, maybe the last 1 or 2 years that we've seen that we don't have that urgency to get out and vote, and the purpose of getting out to vote, how important that is, okay? You know, I during Martin Luther King holiday, there are several programs that come on, but I looked at the one that was really touching to me was the one regarding the March to Montgomery, okay, where people were beaten and were denied the right to vote, okay, and now we do have the right to vote, and we're not exercising that right. So I think that it's changed from the time that we were members of OPPVL,
exactly,
okay, to now, okay, because I mean that was our mission. We were trying to get people out. We were getting people out to vote. Okay?
And now it's not realized how important it is in the minority community.
No, exactly. I wish everybody could view that movie, March to Montgomery, where they showed how those people were actually beaten. They went to register and they were dragged down steps and beaten, okay, and said they couldn't even register to vote.
Because it's important to get individuals to elect individuals who understand your culture, your way of life, and also have a sense of understanding for you as an individual when you come when you get into the judicial system.
That's absolutely right. That's absolutely right. And I bring my personal experience and my sensitivities the things that I've learned in the community, okay, I bring those to the bench. And there's no judge that cannot tell you that they can't bring some of those things to them, although we're impartial, but those factors certainly influence.
Who were your influences along the way, your personal and professional influences?
Well, I'd have to say, of course, starting with Charlie, who was an excellent lawyer. Charlie Elwha, okay. Of course, Jackson V.A. Cox was a very good teacher about politics, especially. I won't even say especially New Orleans politics, because politics don't vary that much around the country. We had the same purpose, okay. So politics in general, okay. So he played an influence on my life. Dutch Moria, okay. I would have to say played an influence on my life with respect to how he handled certain situations, okay, in the political realm. My pastors, okay, Pastor C.S. Gordon, okay, who's has been able to of course, my spiritual leader in giving me guidance. So those people have affected my life.
Now we have about 2 minutes or so remaining. But the challenges that you're faced with in terms of revenue development in your office, and also where you want to carry the office, the magistrate's office, over the next 6 years? Well,
what I like to do is implement more of what we call therapeutic justice. Okay, and therapeutic justice means that, and I have a great opportunity because I'm the first ones, as I indicated, that they see after a person's arrested for a state felony or state misdemeanor. And at that point, I have an opportunity to judge those individuals and to try to identify initially why these crimes may have been committed and how I might be able to prevent them or to help these individuals. So what I like to do, we don't have this now, and I've gone to Washington D.C. and talked to people in the Department of Bureau of Justice to try to get a grant. And if I get successful in getting the grant, what I like to do is have a program where those individuals, first-time offenders, especially substance abuse, okay, and mental health problems, I want to get them into a program, okay? Release them on their own recognizance, possession of marijuana, possession of cocaine, and now, unfortunately, possession of heroin, which is becoming very dominant. Get them into a program and getting some counseling, but I want to monitor those individuals, okay? And that we don't have in court, in criminal court, we don't have it where we initially get them into a program. Now, once they're convicted, we have our mental health court and we have our substance abuse court, okay? And we have, of course, domestic violence court.
Yes, sir. It's that time.
Okay.
Yeah, time is moving. And again, I want to thank you for joining me. And again, I would like to thank my viewers for tuning in. As always, it's been a pleasure.